Hi, very good morning. Again, a very interesting judgment of Delhi High Court. UK Paints Overseas Limited versus Assistant Commissioner of Income Tax. That is the citation. Issue is issue before the Delhi High Court was whether concluded assessments whether they can be reopened by applying section 149 1C of Income Tax Act. So facts of the case, batch of writ petitions were filed before the Delhi High Court challenging the notices issued under section 148 of the Income Tax Act, whereby concluded assessments for various years were sought to be reopened by the income tax authorities. Even though several issues were raised before the Delhi High Court considered only one question, that is, whether the notices issued were beyond the prescribed period of limitation from the end of relevant assessment year and thus barred by limitation or not. That was the main question. So Delhi High Court took only one question. The controversy relates to application of section 149 1C of Income Tax Act. This was introduced by virtue of Finance Act 2012. This section enables the issue of notice by the tax authorities in respect of any income in relation to any asset located outside India. Very important. Any asset located outside India which had escaped assessment for a period of 16 years from the end of the assessment year in which such income was chargeable to tax. So Income Tax Act said for 16 years your assessment can be reopened if your asset is located outside India. And this was introduced with effect from 2012. The contention of the assessee was that this section would apply only in cases where the limitation for reopening the assessment had not already expired. If the limitation has already expired, concluded assessments, it cannot be reopened. That is the point canvassed before the High Court. Naturally, Revenue said nothing doing, even the concluded assessment can be reopened by applying this section 149 1C. That was the contention. In brief, section 147 of the Act enables the assessing officer to initiate proceedings of assessment or reassessment. Under that section, AO could assess or reassess income for an assessment year where the original assessment had been concluded, provided AO had reasons to believe that income chargeable to tax for the relevant year had escaped assessment. So this is a normal section. AO could assume jurisdiction to assess or reassess such income by issuing notice under section 148 of the Act. Section 149 of the Act restricts issuance of a notice under section 148 if period prescribed under the said section has already expired. This is the simple 147, 148, 149. Delhi High Court noted the various amendments that were made to section 147 and 149 of the Income Tax Act. Let us not get into those details. Section 149 1C was brought into force with effect from 1/7/2012. As per the language of that section, the prohibition to issue notice would not apply in respect of income in relation to an asset located outside India which was chargeable to tax but escaped the assessment till the expiry of 16 years from the relevant assessment year. This is section 149 1C. This was brought with effect from 1/7/2012. That is, if your asset is located outside India, then the assessing authority can assess the income in relation to that asset till the expiry of 16 years from the relevant assessment year. Then Delhi High Court considered the judgment of the coordinate bench of Delhi High Court in Brahmdatt versus Assistant Commissioner of Income Tax. This was brought to the notice naturally by the uh, assessees. They said this issue is squarely covered by this judgment, Brahmdatt versus Assistant Commissioner of Income Tax. So the same issue is now before this court. It should be decided in our favor. That is the case of the petitioner. In that case, in Brahmdatt case, Delhi High Court held that the provisions of Section 149 1C would not have any retrospective operation and said the issue is squarely covered. Delhi High Court agreed, yes, it is covered. However, the revenue argued that the judgment in Brahmdatt case requires reconsideration as the judgment did not consider the explanation given under Section 149 of the ID Act. So, revenue argued the explanation was not considered. What is that explanation? The revenue contended that the general rule of all the statutes, other than those which are declaratory or relating to matter of procedure, are prima facie prospective, except where the statute has provided expressly otherwise or by necessary implication. That is what the argument. They said, yes, it is prospective unless the statute has provided expressly or by necessary implication that it is retrospective. Delhi High Court noted that explanation to Section 149 of the Act expressly clarified that the amended provisions would also be applicable for any assessment year beginning on or before first day of April 2012. Even though it came into existence with effect from 1/7/2012, the explanation specifically said that it will be applicable for any assessment year. That is also any is an important word. And then it said beginning on or before first day of April 2012. The import of using the word any is not restrictive. Delhi High Court said that. Similarly, Section 147 was also amended and explanation 4 was added to the same effect. Delhi High Court also referred to the notes on classes of the Finance Bill 2012, which indicates the legislative intent for amending Section 149 of the Act. So, the Delhi High Court, the Finance Bill was brought to the notice of the Delhi High Court in the present case and said the intention of the government is also to make this section retrospective and not prospective. In the opinion of the Delhi High Court, the decision in Brahmadatt case neither construed the import of explanation added to Section 149 of the Act, nor the import of explanation 4 added to Section 147 of the Act, as were in force at the material time. So, in Brahmadatt case, the the arguing councils never brought it to the notice of the High Court. High Court also missed it. The decision in an additional commissioner versus Jodi traders was also instructive. Further, the notes to clauses to the Finance Bill 2012, construing the legislative intent behind the amendments to Section 147 and 149 of the Act, were also not brought to the notice of the court in Brahmadatt case. That is what this Delhi High Court, in this case, Delhi High Court noticed. Delhi High Court held that the view expressed in Brahmadatt case, it requires reconsideration because they did not, the Brahmadatt case did not consider the explanation to Section 147, explanation to Section 149, because they said the explanation said that it will be effective on or before first day of April 2012. The word any also was not considered, and also it failed to notice the object and purpose of the act said in the Finance Bill. Hence, in the opinion of the Delhi High Court, it said the Brahmadatt case requires reconsideration, and hence referred the matter to Chief Justice to constitute a larger bench to decide the issue. Thank you very much. Have a great day. Bye.